very dangerous to our constitutional democracy she speaks about. A rotten NPA is dangerous to the Constitution of the Republic of South Africa. So you cannot protect an individual over the Constitution of the Republic of South Africa. Just her failure to respond to this question, she must take a bag and go. She's not going to be useful to us. We are asking names. That's why we are here. We are told there are people who kept people is names. Who are those people? We want names of drug cartels. We want names of corrupt police. We want names of corrupt judges. We want names of corrupt prosecutors. That is the whole idea of us being here. So you call a witness, when she left home, she left saying she's going to do what here? She's coming to read a policy statement in an inquiry. Yeah, we even discussed boardroom. We're discussing a pillow talk. Yeah. Yeah. That's how far we go. Now we're being told, no, just a name. We can't be given a name of a prosecutor who's suspended. I know that there is a prosecutor called Chauke in Gauteng who's put on a special leave or suspended by the President of the Republic of South Africa. It is the President who communicated that publicly. What is so difficult for an NDPP to refer to such a case and say, for instance, we've got this case that is on, but I can't give details. This is what it involves. A lot of people came here and said so. This is a public information. But to come and say, I won't give you names, even on matters that are public, that is having taken a conscious decision that I'm not going to cooperate with them and I'm going to show them that they can't do anything. She's completely undermining us. To put it mildly, she's undermining us, and she left her home having taken a decision to come and undermine us here. What is so secret about telling us about a public prosecutor, of a public prosecution? Everything is public there, except when you are dealing with the case. It says, I will give you a name when a person appears in court. The person that we're speaking about, for instance, Chauke, he's not going to go to court. It's an inquiry that is on. The president is investigating a particular conduct, wrongly or rightfully, I don't know. So it means we'll never hear that name Chauke in this committee, because he will never have a first day appearance in a criminal court. What happens? There is an internal, inquiry that the president has constituted. The head of NPA must know about that, must be comfortable to speak about it. And the refusal to speak about such an incident is to say, I'm not going to cooperate with you. Actually, the allegations goes further, which we're going to probe later when it is our turn to ask questions. They say, after they arrested Advocate Chauke, they are able to register cases easily. That's what SAPS says. And cases are moving smoothly in Gauteng. Is that true? We want to get into those issues, but if the head of NPA is going to shy away from that, then which issue are we going to deal with? We need prosecutors who are cooperating with drug cartels.
Thank you, Honorable Malema. Honorable Sauls.
Chair, indeed, advocate is required to give us names. It is true. However, it is not true that names has been given in this committee. We still don't know the names of 3 out of the big 5. Why? Because the witness stated that it is under investigation and the names will be revealed, and it can be revealed in camera. It can be revealed in a closed session. So we must be honest about this, that it is true that advocate must give us the names. But the question is not must you give us the names or not. you must give us the names or name. But the question is, how? Which platform? What is the requirement for you to give it in closed session? If we go by what has happened in the past in this committee, the statement was, I cannot reveal in public the names of the other three of the big five, even though the committee wants to know, and that's what we are investigating. It's because it's still under investigation. You testified, advocate, that the person you are referring to is suspended, but the suspension is not connected to the allegations that you are referring to. In other words, whatever you are referring to is still under investigation. And it is for that reason that you don't want to publicly reveal the name, if I understand you correctly. This then satisfies the same requirements that was put forward before. Where I will disagree with you, advocate, is if we say to you, you must reveal the name, but you must reveal it to us in closed session because it is still under investigation, and you refuse at that point, then I will disagree with you. Because that would be you intentionally hampering us from doing our work. But if you are willing to reveal the name in closed session, that would be in line with our terms of reference. So, Chair, I support the position that the advocate must reveal the name. But if the advocate opts to do so in closed session, that is in line with our terms of reference, and she should be allowed to do that. Thank you, Chair.
Advocate Breitenbach.
Thank you, Chair. Chair, I understand the need for the members to hear the names, and we all need to hear them. Advocate Batohi has made it quite clear that the person she is referring to has not necessarily been suspended for the facts that we are now talking about. And she doesn't have control over the investigation, and the other agencies that are involved in, obviously involved in such an investigation. And so for her to sit here and publicly name people could not only undermine the investigation, but it could also undermine other agencies who are busy with important work. And so I would agree that she must be fully open and honest with this committee, but not in an open forum. And for the sake of progress, I think we should move on with everything else and then deal with this issue at the end, and in a closed forum. Thank you, Chair.
Honorable Sangwan.
Yeah, thank you, Chair. No, I think I've generally been covered by all the members who spoke, and I align myself with the recommendation on the closed session. Chair, because we were discussing this matter and we don't need an answer now, I can wait until we're questioning, but I'm hoping that Advocate Batohi is also going to give us the reasons why she recommended to the President that Advocate Chauke be suspended. I would appreciate that we get that. Thank you, Chair.
Bangazit.
Thank you, Honorable Chairperson. One, I actually wanted also to align myself with the shall I call the demand by this committee for the name to be actually mentioned. However, I do want to support Honorable Ngola in the proposal that he made, namely that perhaps at the end of this process, the NPA, whether it would still be Advocate Batohi or the new one, be able to actually supply us with the information related to the matter that we are dealing with right now, including the name. But I also am not comfortable if the advocate simply refuses to give the name, because names have actually been mentioned here. And Mkhwanazi did not actually beat about the bush in saying categorically that within the NPA, there are elements that have actually compromised the operations of the criminal justice system. So we cannot be overprotective of individuals, because we might be protecting the very element that we need to know about and deal with. Thank you.
SC.
Thank you. Thank you, Chair. I was going to propose just a short adjournment for Advocate Batohi to confirm with Council to consider making the disclosure in camera. Thank you.
No, I will grant you that time during lunch, during the break, because I think we should go ahead with the work of the committee. Advocate, I think you hear the sentiment of the committee, that the committee, one of its terms of reference, which we read to you this morning, is that it is also investigating alleged corrupt relationship between officials in public institutions in the criminal justice system and members of the public. And if we are going to successfully do that work and report to Parliament, but also when I carefully listened to you when you made your opening statement, you say this ad hoc committee and the commission, the work that they do provide an opportunity for Parliament to make necessary interventions in the strengthening of the law that we have. So it's going to be very important that we have, remember the reason why we want the names is we have to decide on the witnesses that we invite before us here. And if we don't have those names, all these witnesses, the reason why the committee said the first witness must be General Mkhwanazi was because we couldn't just sit like this and throw the bones on the floor and the bones will say there is an elephant here, there is a lion here, there is a porcupine here, you must call them before. General Mkhwanazi came here and named institutions and mentioned names of officials, and we were able to make decisions on who we must invite, who must be a key witness, who is secondary witness, and the order in which those witnesses must appear before the committee. So I will take solace to what the SC says, that during the break, I mean, when you come back from the break, you will give an answer as to how that name is going to be made available to the committee. And in this regard, I would like us to continue with the proceedings. Is that fine with you, Advocate?
Chair, it's a good first step. I will certainly confer with Council during the break. Whether we'll be able to come back immediately or whether I need to get a proper legal opinion on this is something we will consider. But I really want to assure this House I do want to cooperate with this House. And I certainly do not want to be disrespectful. This is important work, as you put out. So we will certainly look at how we can best deal with this issue. Thank you, Chair.
Thank you, Advocate Batohi. Can we perhaps just explore this very issue a bit further? What is the difference between the suspension of Advocate Chauke by the President? Is it because he's a DPP and this particular prosecutor is not?
Advocate Chauke has been suspended by the President because he is a DPP. That is correct.
So the suspension in this case would it have been effected by you? As the
Well, it depends.
NDPP
As
or-
I said earlier, Council, I don't want to say anything further because it could reveal the identity of the person.
Yeah, I'm just trying to explore what the reasons might be. I can understand from a reputational point of view that someone's name who's still being accused not be disclosed. But it is so that many names have been mentioned during the course of these hearings, and members understand it's on the basis that there are allegations. But there may be a different perception out there in the public that I can also understand. The other thing is this, you actually mentioned that the reason for the suspension is not related to what was mentioned to you by, I don't know, just you can correct me if I'm wrong, by Lieutenant General Kumalo and the National Commissioner. It is for some other reason.
That's correct.
Isn't that a reason why perhaps the name should be mentioned? Because I think the concern is that given that allegations have been made by, amongst others, Lieutenant General Kumalo and also the National Commissioner and Lieutenant General Konazi, that this appears to be a person who's been suspended, but not for the reasons that they allege. So why can't the name be mentioned?
For the same reasons that I mentioned earlier. And I'm not sure if you want me to repeat those.
No, that's fine.
Chair.
We did say that, I think that the chair did point out that during the break you can consider your position and take legal advice and get a legal opinion if necessary. Because as you know, we in a different forum to the Madlanga Commission. You are also protected by parliamentary privilege. And it's parliamentary privilege is only lost if at the end of the day you are found to have lied or for some unlawful reason. So you are protected. So you are in a protected environment. You're not persuaded.
I'm in a protected environment. I'm trying to protect others
Well,
for the reasons that I mentioned.
I think that person will understand that you have to make the disclosure because of parliamentary privilege that protects you, and now there is a request, strong request, from the committee that the name be disclosed.
Chair, I ask that I be permitted to seek legal advice on this matter and come back to the committee, but I assure the committee again that we do want to cooperate. I do want to cooperate fully.
I think that's why the chairperson had, like with other witnesses, read out the oath and even before that explained what this committee is all about. Okay, if I'm just, I think we were going on to the statistics that you mentioned at paragraphs 71 and 72. This is all in relation to misconduct cases in the period from 2019 until March 2025. You want to discuss that briefly? 71 and 72?
Yes, so in terms of the NPA Act, there is a provision that allows for the creation of such an office to deal with issues relating to integrity. There was an integrity management unit in the NPA. But that was not in terms of the Act. We've now, in terms of the Act, set up the Office for Ethics and Accountability. And it's responsible for handling or investigating any complaints relating to improper conduct on the part of a member of the NPA. But not just reactively, it is also responsible for promoting a culture of ethics and accountability within the institution. So there is a proactive part to the functions of the OEA as well as a reactive part to it. And so we've, the Office of Ethics and Accountability, and as we say, its precursor, the Integrity Management Unit, has received 58 complaints which relate to allegations of corruption from 2019 to 2025. 31 were closed as unsubstantiated, 16 referred to labor relations, and 7 were classified as representations linked to particular cases, which means there's another process to be followed and not a disciplinary process, and 4 are investigation. Of the 11 matters that were concluded, 8 employees were dismissed, 2 resigned, and 1 was found not guilty. But the Office of Ethics and Accountability is really a very important development in terms of trying to inculcate a culture of ethics and accountability in the National Prosecuting Authority, and making it clear that to prosecutors, that we serve only the people of this country. We are the people's lawyers, and we pride ourselves on being just that. And that we serve only the people of this country. We should act as the Act says, without fear, favor, or prejudice. And this, the Constitution and the NPA Act. And this shouldn't just be a cliche. It should be demonstrated by the work that we do, that we in fact act without fear, favor, or prejudice. So this office is very important in terms of ensuring that we inculcate a culture of ethical conduct in the NPA, of the highest standards of integrity. And if these are breached, that they will be properly investigated and there will be consequences. The one thing I can assure the people of this country and this House is that when there are allegations against any prosecutor, we do not sweep it under the carpet. It's a fair process, it is properly dealt with, and there are consequences.
The issue of the suspension of this potentially corrupt prosecutor, was that referred to the Office of Ethics and Accountability? Because I see it's been referred to IDAC.
Yes, it's been referred to IDAC because I believe that there should be a criminal investigation into this matter, and we needed to get more information, because I just got, as I said, some kind of information, so we needed to look into it more carefully to ensure that at the end of the day, we can decide on what processes should follow from there. So this is the first step in what could lead to other processes as well.
But still on this theme, I'm afraid, given the seriousness of the allegation, I'm talking about this particular prosecutor, but also given, as several honorable members have pointed out, given the importance of the work that the NPA does, given that we all accept that trust in the criminal justice system across the board, NPA, the police, other law enforcement agencies, is at its lowest. Isn't a last and the more effective deterrent to name and shame errant or miscreant prosecutors, rather than going through this formal process, which one understands that must be followed, given that you've got to weigh up the rights of those accused and the accusers.
Chair, I agree.
If prosecutors should know that an allegation is made against them, it might be made public.
Chair, I agree that errant prosecutors should not be tolerated in the prosecuting authority, and there must be processes. We do not, as the NPA, make any comments about internal disciplinary processes that are ongoing. That has been the policy of the NPA. But it's not because we are protecting anybody. Processes do, as I said, when there's allegations, we make sure there's a proper process, whatever it might be, and there's consequences. Because there's absolutely no room for errant prosecutors, dishonest prosecutors, corrupt prosecutors in the NPA. And so I'm not sure whether the council is going back to, your question relates to disclosing the name of this person. But again, I'm imploring that we be given the opportunity to consult and decide on how we take it forward. And a closed session which has been proposed might be the best way forward. So I would urge that we be allowed to at least take advice on that.
Okay. Can we also perhaps just jump to the actual reason why you're here? That's in relation to allegations by General Mkhonazi in relation to the PKTT, the Political Killings Task Team. I think you attended a first meeting, or one of the first meetings of the Interministerial Committee when it was, the Interministerial Committee was established in 2018 in May. You were appointed in 2019. Subsequently, did you attend any meeting? What was your first sort of contact with the PKTT?
Chair, if you can just refer me to the Honourable Council to the relevant paragraph, but just to say that it was in 2019. I'm not sure, but it was earlier in my tenure that there was a meeting in Durban. The meeting was attended by the Minister Kele at the time. It was Commissioner Sitole who was there, and the DPP of KwaZulu-Natal was there. There were members of the PKTT. I don't know who was there from the PKTT, but it was about the Political Killings Task Team and having a dedicated capacity of prosecutors to support the work of the PKTT. And so that meeting was held in Durban, where we reached agreement in terms of how the NPA will work, the NPA in KZN will work with the PKTT. That was the one meeting that I did attend.
But you yourself, you weren't involved. I think we reference it from page 13 of the statement.
What paragraph is that, Council?
From paragraph 31. Sorry. There isn't a specific reference because of your own direct involvement is not with the PKTT at all. What you do reference is that Advocate Harrison, DPP of KZN, was involved with the PKTT, with the prosecution guided intervention that she made. You're aware of that?
Yes, that's correct, Chair. I am.
And you would have received the reports from her from time to time, certainly on an annual basis, about the work that they were doing with the PKTT.
Well, not specifically just the PKTT, but DPPs submit reports to the National Director, and we include various aspects of the operations of a DPP's work in a province. And so in the context of that, they would have been reporting, and there may or may not have been reports that related to the PKTT in that context.
And she, in relation to her own experiences, she has given evidence elsewhere, and that can be referenced.
Yes, absolutely. She's testified at the Madlanga Commission, and if necessary, she can testify before this committee.
But in the almost 7 years now that you've been in this position, is there anything that stood out for you about the work done by PKTT, whether it was a successful task team or unit, in relation to resolving political killings in particular in the KZN province?
I can't comment on whether they were successful or not, but if, you asked me about anything that relating to the PKTT that I was involved in. There was a time early in my tenure when there were complaints by the police, I think it was particularly Minister Kele, that the prosecutors were not enrolling cases were from the PKTT. And there was a bit of a problem between, in terms of how the prosecutors and the PKTT investigators were working. And there were a number of dockets that were referenced that the police were not happy about. I then got a report from the KwaZulu-Natal DPP about each of those cases, with reasons why the cases were not enrolled. But that is the one specific instance that I recall about getting a report on cases being dealt with by the PKTT from the DPP KZN. Apart from that, there's no specific issues that came up regarding the PKTT. So I cannot say whether it was successful or not. It was something that the DPP will be able to testify about. They did work in the prosecutor guided model that you mentioned earlier on. This model, I deal with it in my affidavit. I'm not sure in which paragraphs.
It's from paragraph 62 onwards, and you discuss it in the context of the functioning of the criminal justice value chain and the role of prosecutor guided investigations.
That's right. So
which relates to paragraph 4.1.8 of the Honourable Committee's terms of reference in relation to interagency coordination among SAPS, crime intelligence, IDAC, NPA, correctional services, Metro Police, and the legal basis for directives affecting the PKTT. It commences at paragraph 56.
yes, thank you, Chair. And so, the importance of working together with our partners in law enforcement is hugely important. I mean, to state the obvious, the system can only be as strong as the weakest link. And I'll get to the prosecutor-guided model, but this is just one example of how we have tried to work very closely with the South African police in particular in utilizing this model so that prosecutors and investigators start working from a very, very early stage together in order to ensure that the evidence is something that will meet any kind of challenge in court. And so this model is not peculiar to the PKTT. It's a model that's been adopted for many years in the prosecuting authority, starting from when the specialized commercial crime units were set up. It's over 20 years ago, I think, when the police and the prosecutors co-located to deal with serious economic offenses, commercial crimes. And so we've also utilized this methodology in the PCLU, the Priority Crimes Litigation Unit, which deals with certain types of specialist crimes, for example, international crimes, as well as terrorism. And the organized crime component also utilizes the same methodology. And if there's a case that is complex or high profile enough, and we think there's a need for prosecutors and police to work closer together, the same methodology is adopted. And so, it really...
So just to pause there, it's not only in relation to a specialized unit or particular task team. That model would or could also be adopted in relation to a particular case, a case of some complexity.
Yes, absolutely. So, this methodology can be adopted at, under as long as the criteria are met. It's sufficiently complex.
What are the criteria?
complexity, there's, it depends on the gravity of the offense, the complexity in terms of corruption. There's often layering, money laundering involved. But it could also, where you require data analysis, lots of forensic work to be done, really enhances the complexity of investigations. But we could also, a matter could be high profile, but not necessarily complex. But because it is something that is a priority case, we might then say, look, there's a need for prosecutors. It could be a murder matter. That's a high-profile matter, and prosecutors and police officers need to work closely together. Then we would say, look, this is something that we should adopt this model in.
I asked that because there is some criticism. For example, why is such a model not employed here, say on the Cape Flats, where it is notoriously, it's a notorious fact that it's controlled by gangs, 27, 28s. We now see the high-profile prosecutions currently in court with Modak and Donkey Boyson and people like that. Or is it a case that they were brought to court having adopted the same model?
Absolutely, that is the response. I did say organized crime cases as well, and the cases in Cape are a good example of that, where this model has been employed rather successfully, because prosecutors, investigators working very closely together in extremely difficult circumstances and dangerous circumstances to bring to book some of the most violent and dangerous organized criminals globally.
Now, you wouldn't be directly aware, but the PKTT, their reach had also been extended beyond KZN. For example, they were investigating the alleged corruption at Fort Hare and made a number of arrests there. And then also in Gauteng itself, going into and arresting Molefe and assisting the Gauteng murder and robbery unit in Gauteng. Would that have also been pursuant to adopting the same approach?
Yes, definitely. In those cases, in the Fort Hare matter, although it was a political killings task team, but their mandate clearly had expanded to include, in the Fort Hare matter, it's an economic commercial crime, commercial case. And so they were involved in the University of Fort Hare matter. And I am aware that they also were involved in Gauteng.
Has this approach enhanced and improved the success in the rate of prosecutions at the NPA, especially in relation to high-level crime, organized crime, drug syndicates, and so on?
So it certainly has, in some very, very complex matters where prosecutors and investigators work together. I don't have the figures here. I can certainly give you, I think I'm not sure if I've got the organized crime stats, etc., in terms of successful prosecutions, but I can get that.
We have your annual report.
Yes, we can certainly get those figures. They are all in there. So it's a model that works. It's an internationally recognized model, and we do have evidence that it is better. But I do think that the model itself can be improved, because even with some very complex matters, we find we're not moving as quickly as we should. And those are because of systemic problems, whether it's, lack of capacities, capabilities, whether it's corruption within our ranks. But some cases just don't seem to be moving, even though this model is adopted. So there are various challenges in the system, and the model can only be as effective as the efficiencies in a system as a whole. But we have found that where we do employ this model, it does work better in terms of the results.
Because as you well know, better than anyone actually, that there is a lot of frustration amongst members of the public, even the honorable members in this House, that that the high-level criminals are not being prosecuted successfully and not being seen to get into what is called orange overalls. Or you can also in that context discuss several of the referrals that were made from the Zondo Commission to the NPA and the prosecution of those individuals.
So I think firstly, Council, if, before I answer your specific question, just in terms of coordination as a whole, the PGI model is just one, that's a prosecutor guided, is one model. But I think a really good example of how we did well as a country was coming out of the FATF grey listing. And that was really an example of how, when we as government come together with a common objective, and we put the necessary skills, resources, capabilities, and energy into making sure we get over the line, we can do it. And the FATF collaboration is an excellent example of, because you have, it's not just law enforcement, it's government, it's agencies across government. So we're looking at Treasury, we're looking at the Reserve Bank, we're looking at state security, the police, SARS, the NPA, and all of these entities, the Department of Justice because of mutual legal assistance. So a whole of government approach in 2 years for us to get over the line, to get off the grey list, was a monumental effort by various entities in government. But again, it's a really good example that